Good
We're
afternoon.
going to start a little early in anticipation of maybe so lots of questions. I wanted to introduce my friend Tarek Shoki. He's was a public defender. He's now a criminal defense attorney. I've known him and his wife and kids for many years. We've talked a lot about criminal law and dependency law. There's been some crossover. On occasion, he worked once on a case where a Little 2 attorney was appointed on the dependency matter, and he was in the criminal matter. There's an email sent out to everybody about the presentation, and it had a little bit of his bio. So I just want to let you guys know, without repeating word for word, that he's a former public defender in LA and Riverside. He's a member of a lot of different boards in LA and Pasadena. Overall, great guy. So please give a warm welcome to Mr. Tarek Shoki.
Thank you. So this is my first time giving an MCLE, so I'm a little bit nervous. But I do remember many times of being a recipient of MCLEs and wanting more issues addressed that were on my mind that weren't necessarily addressed. So I would like to start by asking you guys if you have any specific cases or things on your mind, so I can kind of try to tailor more to what you're interested in rather than what I think you're interested in or what I think that you want to hear. So you don't have to tell me right now, but as we go, you can feel free to raise a hand, point a finger, what about this? Because again, I'm trying to make this as useful as possible for you. And for the record, public defenders are defense attorneys too. And I was a public defender for 6 years, and then I went private. And I feel like we have a lot in common, PD and LADL attorneys, talking to him about caseloads, just the nature of walking into a situation where your client's head is spinning and they're stressed out and they're looking to you as their salvation with, wanting you to answer all their questions, or what about this and what about that, and I'm sure you guys get that, am I going to go to jail, or what's going to happen with the criminal, what's going to happen with my family law issues. We get the same. Whenever I have a case involving child endangerment or anytime a child is taken, obviously they see an attorney and they assume that I know everything about dependency. So they ask me, how do I get my kids back? What do I need to do about this? And unfortunately, I don't have most of those answers, so I try to corroborate with you guys whenever I can to get that information. Like you mentioned, I had a great experience with Jody Pace on my last case in Alhambra, where kids were taken away because they were left in the house while the parents went to Roscoe's for lunch. Were gone for 4 hours, and when they came back, the police were there, and they obviously took the child. And I didn't really know what to tell them about what's going to happen, how long is the kid going to be gone, how do they get them back. So it was super helpful to have somebody who had all those answers, and specifically to my specific case. So yeah, I encourage you guys to corroborate as much as possible with defense attorneys if you have their contact, because we're oftentimes in the dark about what you guys do, and it's super helpful for us to be able to set the client at ease a little bit and kind of walk them through the process. So, introduction. So here's some of the issues that I thought would be important. And again, if there's anything that comes to mind initially or as we go through, please raise your hand and I'd be more than happy to address those. So, the negative consequences are always on my mind when my clients are going to get arraigned and I know that they have dependency court. I'm always thinking about, okay, how do you not incriminate yourself when you go to dependency court? How do you not throw yourself under the bus in an attempt to do or say what you need to do to get your kids back? And I try to counsel them beforehand, but I know that when they get here, they probably forget everything that I told them and will do whatever you tell them at that point, because again, their priority is their kids. So I think one of the things is, sitting down with them, getting the whole story, and then making sure that if they do speak, that there's certain things that they're warned about, or at least put on notice that, this is potentially going to affect you in criminal court in this way. And I talked to Jabbar about this before, about postponing hearings until after the criminal case is done. And I guess your judges are not so keen on letting that happen in the timelines. And, sometimes, we're going to get into the timelines a little later, but sometimes like a misdemeanor, if a client wants to assert his speedy trial right, does anybody know what the speedy trial time is for misdemeanors? No? All right, good. I feel like I know. So it's 30 days if you're in, 45 days if you're out. So if a client is out of custody and he wants his criminal case to wrap up quick, it's 45 days before a jury's impaneled and trial starts. So realistically, like 50 days. So If a normal continuance of your case is 45 days and he doesn't waive time, chances are we'll either have that case wrapped up or trial will be started and they won't be available to come to court for your case. But I guess that's one way is advising them that, hey, this is a misdemeanor, tell your public defender or private attorney that you don't want to waive time and you want to get this case done quick. And if they don't waive time, then it'll happen in 45 days. If they're in custody, you guys still get them in custody transported. So you can tell them 30 days and you'll see them in a month and hopefully the case will be wrapped up at that point. And then they can say anything that they want to the judge because at that point the matter's been adjudicated and you don't have to worry about the negative consequences. Coordinating with criminal attorneys, how much success, I'm curious, have you guys had with being able to contact a defense attorney who's assigned to a case?
Mixed bag.
Mixed bag, right?
We usually able to contact them.
Okay, good. And how often does it happen? Like, I mean, at some point, I'm sure some cases are not necessary, but I'm curious, because I haven't gotten too many calls from LADL attorneys, so I'm curious how often that happens. You know, out of every 10 cases, would you guys call an attorney 1 or 2 times, 3 times?
Maybe one at a time.
Okay. And is that because it's not really, you don't really need any information from them, I'm guessing? Okay. So, just to give you a little bit of tools in terms of, you know, knowing what we need in terms of keeping them out of trouble and keeping them from incriminating themselves. There's the code section and then there's the jury instruction. First of all, to find out how they're charged or what they're charged with or what charges are pending, that's all public information that you can get off of the LA County Court website. And all you need to know is their name and their date of birth. If you have a case number, it's even easier. But the website on the material, lacourt.org//online/criminal. Name, date of birth, it's a free search, and you could see everything from the charges, the next court date, whether it's an arraignment or a pretrial hearing or whatnot. And unfortunately, a lot of our clients walk out of court not knowing exactly what they're charged with, they just know that they have a criminal case pending. So if they're not able to help you, that's where you would access that information.
Really quickly, if a dependency lawyer doesn't really need to speak with the public defender because it doesn't really affect their case, would you recommend still the LADL attorney to contact the public defender if possible, and why?
Alright, so for Lancaster, your question is, do you still contact the public defender even if they don't think that it's particularly necessary? You know, it's if there was a best practice, I would say it would be good to work together just so that you guys are on the same page. Because there may be some criminal issue that you're not aware of and there may be some dependency issue that they're not aware of. So if you, I know that when I say if you have the time, I remember it being a public defender and the answer is always never. But if you have the time and are able to reach out and shoot an email or something, I think it's always better to have that information in your realm. And it also gives you a little bit of advantage over the other side who may not have that information. So I would recommend yes, if you can make that happen.
What kind of information would be helpful to the public defender from a LADL attorney? Okay, is there any information that we can provide that would help them guide in terms of sentencing or pleading or length of time or what jail they can go to?
I think just being able to communicate to the PD what the situation is, because at the end of the day, a lot of my criminal defense clients, their main goal is how fast can I get my kids back and what do I need to do to get them back. And there's certain charges that are more problematic in dependency than we realize. As criminal attorneys, we don't necessarily know what charges are going to be more difficult for them to get reunification. So I guess just an overview about, factually, some of the things, and legally, what are the things that they shouldn't plead them to because it'll have negative consequences. So I think criminal defense attorneys definitely need a lot of education on the LADL side of the law and the dependency side of the law. The same way we need a lot of help with immigration. A lot of attorneys will plead somebody out to cases that get them deported, not knowing that this charge is a deportable offense because it seems like a misdemeanor and it seems very minor. So just having that conversation and saying, hey, be advised, here's some of the pitfalls that you may not know about. It'll ultimately help your client tremendously and educate the defense bar over time. The other interesting thing is, once you know what the charges are, if you look it up on the website, knowing the charges is part of it, but then the jury instructions are really what we go off of in criminal court, because those are where the elements of the crime are that have to be met in order to sustain a conviction. So when you're in trial and the trial's over and the judge says this is the law, he doesn't read the penal code section, he reads the jury instruction. And sometimes they're very different. The penal code can be more vague in terms of, this is what the violation is, but the jury instruction will actually lay out if these 3 elements are met, you can convict this person of a crime. So if you're going to go through the trouble of looking up what they're charged with, it's also useful to go to the CalCrim jury instruction, which is published by the Judicial Council of California, and the link is there. And look at what the elements are so you know, okay, so this is what the elements are, so my client can't actually talk about these things because none of those things are actually listed in the elements. So you can kind of tiptoe around incriminating evidence by, sticking to facts that are not actually elements of the crime. So, if that makes sense. Is that clear? Okay. And regarding, this is a little jumbled, but when you go to the county court website, the case summary, that's the one that is a free search, and it's public access, so anybody can see it anytime they want. And the jury instructions, it's a PDF file when you go to the Judicial Council website. It's a PDF file with a whole ton of instructions, and it's all there, public access, public record, anybody can see it. So, I'm going to try to just go into some of the basics of the criminal process and timelines and whatnot. And again, if there's anything specific, any questions, please stop me so that I can be more specific and tailor this to everybody's needs. Lancaster, that goes for you too. So the initial hearing in criminal court is the arraignment. The arraignment is supposed to happen within 48 hours of your arrest. And unfortunately, it's usually longer because they say it's 48 hours in terms of like court time. So if you get arrested on a Thursday, Friday counts, Saturday, Sunday don't count, Monday counts, but sometimes it ends up being on Tuesday, and you've ended up in jail for 4 days, but technically they fall within the 48-hour requirement. But the arraignment, basically that 48 hours is supposed to give the prosecutor the time they need to go through the police reports after the arrest, look at the documents, figure out what charges to file, charge you, and then you show up at arraignment, the defendant shows up at arraignment, he's presented with the complaint, charging document, and he's given the opportunity to plead guilty, not guilty, or no contest. And again, that's technically 48 hours after arrest, but realistically it ends up being a little bit longer. And that's if they are in custody. If they are out of custody, that timeline is different. It kind of works the same way as the traffic citation when you sign the ticket, promise to appear, and they set it out like a month or 60 days or 90 days later. It's basically because you've been released on your own recognizance for a ticket, but in case of criminal court, you've been released on bail, so you've essentially waived your right to be arraigned within 48 hours because you're now free, and nobody who's bailed out has ever said, no, I want to go back to court the day after tomorrow and do my arraignment. So essentially, it's within a reasonable time, and it's usually like a couple weeks that you get arraigned. And then the timeline takes 2 different routes from that point. If it's a misdemeanor, you have the shorter timeline, which is the right to a speedy trial within 30 days of your arraignment date. And the right to a speedy trial means that they have to send you to a courtroom and bring in a jury on that 30th day. If the 30th day arrives and they say, you know what, we don't have an empty courtroom in the building and there's no way to proceed with this trial, they have to dismiss the case. And I've seen it done many times. And at the PD's office, we sometimes used to use that as a strategy when we knew that all the courtrooms in the building were booked. Everybody would run upstairs and try to set trials knowing that they're not going to get sent out and basically have to get the case dismissed because there's too many trials already on calendar. So 30 days if you're in, 45 days if you're out for misdemeanors. So the timeline for misdemeanors is a little bit shorter. The timeline for felonies is longer because there's two parts to it. After the arraignment, on a felony you have the right to what's called a preliminary hearing. A preliminary hearing means that the judge gets to hear some preliminary evidence and decide, is this case legit? Is this guy going to stay in custody because I think there's enough evidence here to actually hold him over and set this case for trial at a later date? And the prelim has to happen within 10 days. And it's a much lower standard of proof that has to be proven to the judge. The judge basically has to feel like there's a reasonable belief that a crime was committed and that this person committed it. So surprisingly, sometimes we do get cases dismissed at prelim because once the evidence is out there, the judge is like, wait a minute, we're not even sure if this is the right guy. And the police officer's, well, you know, maybe it is, maybe it isn't, he throws it out. Or, you know, if a witness doesn't show up at prelim and they can't establish one of the elements of the crime, if any one of the elements of the crime isn't met at the prelim, the case gets bumped, gets thrown out, and they either have to refile it later, or the case just gets dismissed outright. So, 10 days from the arraignment, unless the client waives time. A lot of time, if they're out of custody, they will waive time. This 10 days, whether you're in or out, it's the same. You have to have a prelim within 10 days. Otherwise, the case will get dismissed. After the preliminary hearing, they file a new complaint, but they call it an information. It's called an information because it's based on the information that was provided at the preliminary hearing. So usually it looks exactly like a criminal complaint, except at the top it says information instead of complaint. And you have the right to be arraigned on that information 15 days after your preliminary hearing. And depending on what was found during the prelim, sometimes they add charges, which is our worst case scenario, is we never want evidence to come in that results in additional charges being added after the prelim. But a lot of times we're able to knock out offenses because when I was a PD in Riverside, there were a lot of times where they overcharge stuff or throw everything against the wall to see what sticks. So by the end of the prelim, we have like half of the charges that were there at arraignment, which is always fun at prelim as an attorney to be able to get rid of half of the charges, and now their exposure goes down to half, and the case becomes a lot more manageable, easier to resolve, easier to settle if you want to settle it, and easier to try if you're going to trial.
Are those court days or calendar days?
15 calendar days for information arraignment and 10 calendar days for preliminary hearing. So I wanted to give a brief example. Oh yeah, and then after the information arraignment, you have the right to a speedy trial within 60 days of your information arraignment, and that's whether you're in or out of custody. So while a misdemeanor can happen in as quick as 30 days from the arraignment, a felony is usually closer to 75 or 90 days. And if that gives you an idea of how long your clients are going to be stuck in criminal court until their case is resolved, you can find out if it's a misdemeanor or a felony, and then plan accordingly. But I guess you guys don't usually get the luxury of postponing. Feels like everything in criminal case gets postponed forever. But you guys are much more diligent because you have to be. I want to give a brief example of the difference between what the jury instruction looks like versus what the penal code says. 273DA, one of the most common cases involving kids that I've seen at PD's office and in private practice, is any person who willfully inflicts upon a child any cruel or inhumane corporal punishment or an injury resulting in a traumatic condition is guilty of a felony and shall be punished by imprisonment pursuant to subsection H of section 1170 for 2, 4, or 6 years, or in a county jail for not more than 1 year. So if you give that to a juror, obviously they're not going to know what to do with it. They're not going to know how to determine someone's guilt or innocence. So the California Judicial Council laid it out as, 1, 2. To prove that a defendant is guilty of this crime, the people must prove, number 1, that the defendant willfully inflicted cruel or inhumane physical punishment, and basically the judge will go through the jury instruction beforehand and circle and scratch off whatever text needs to be scratched off or added. So cruel or inhumane physical punishment and or an injury on a child, and the punishment and or injury inflicted by the defendant caused a traumatic physical condition to the child, and then traumatic physical condition defined as a wound or other injury, whether minor or serious, caused by the direct application of physical force. So again, I don't usually use the penal code for more than just seeing which code section matches to the jury instruction, because most of our work is going to be about making sure that the elements are not met at trial or prelim or whatever. And clients always show up with the jury with the code section and say, you know, I didn't do this. This says this. That's not what it says. And then you show them the jury instruction. They're like, oh, okay, I can see how I can be convicted of that, given that the instruction is significantly different. The other thing that there's a lot of crossover is the protective orders. We spoke about that, Jabbar and I, before, about how you guys deal with a lot of protective orders and how to modify them and what they mean and what they do. So I was going to get into that for a few minutes, but again, anything that comes up for any, yes ma'am?
One of the things that we come across with some regularity is clients who tell us that they had no idea that there was a CPO.
Okay.
So they'll usually know there was a PPO, but then they'll say, we didn't know, especially if we have the victim,
Right.
because they weren't at the hearing, nobody ever alerts them, they claim they never got one in the mail. So is that true? Does that happen when they just order them and don't ever notify people?
So I've only seen a CPO ordered in court after a conviction, because technically it's a criminal protective order following a conviction of a crime. And if the defendant just pled guilty, the judge will then say, okay, now, you know, have a seat and I'm going to give you a copy of that order that I just read to you, which says, you know, have no electronic or telephonic contact, stay within so many yards, and yada, yada, yada. And they won't leave the courtroom without that. That's part of their paperwork. What I imagine happens is that when you leave the courtroom following a criminal conviction, you have sometimes a copy of your plea form, you have probation terms that are, you know, 1 or 2 or 3 pages. You have your referral to go to your DV class or child abuse class or anger management class. You have a referral to go to some kind of community service, or if you're going to house arrest or whatnot. And you end up with a packet of paper. The last one is going to be the CPO that says, and by the way, you know, here's the CPO that the judge read. So they probably did get served and probably didn't go through the paperwork with enough detail to realize that that was the last document in a stack of documents that they just got from the bailiff.
What about the victim? Because what we hear is that the victim says they didn't know it existed. So they're then in our position being accused of violating a CPO that they tell us they never knew existed. So they let dad come home after he gets released and they violated a CPO.
So the victim doesn't get served with the CPO. Yeah, they don't get service because it's assumed that it's there to protect them. And in every protective order, usually the victim who goes in and applies for it won't get service per se because they're the ones who filled out the document, so they assume that they have the original. And because they're not a restrained person, there's no legal requirement that they be served or noticed because they assume that they requested it. But in criminal court, because it's an automatic thing that after a DV case, the judge automatically serves a protective order, he'll sometimes ask the victim if they want it to be a no contact order or a no negative contact order. But beyond that, the victim won't get service. So sometimes they don't even want them. And sometimes they come in like right after the case is done and they're like, what did the judge say about protective order? I don't want a protective order. You know, we want to get rid of that protective order. And then we'll have to put it back on the calendar, have them come and address the judge. The judge asks them a lot of questions to make sure that it's not coerced or that there's some other reason why they're asking for the modification. And they can get it modified after the fact. But yeah, that is a good point. A lot of times they have no idea. A lot of times they don't want it there in the first place. And which would make sense why they invite dad back and then dad gets in trouble. And I guess it's a double-edged sword because you can legitimately tell the judge, well, they didn't know it was there because they weren't served with it, which is true. And that could be a defense, I imagine, why she invited him back and why he didn't know that he shouldn't come back. Yes?
In the last week or so, I've had a very curious conversation with a PD on one of our cases in which he was able to get the judge to check the box that says it allows for, visitation with children. Yeah. And it's the restraining order because it was a felony child abuse case that they're now trying to reduce down to a misdemeanor if the person goes through all their programs.
Right.
What's curious to me in talking to the public defender, and I don't quite understand this, is when they went back the second time to the court, I was trying to explain to the public defender that if we have a parent who's trying to reunify, the way our judges look at that is I don't know how you can have peaceful exchange, but you can never have a return to custody as long as there's a restraining order, because it's just limited to peaceful exchange. And the public defender said no, as long as he can get the box, the stay away order box removed, that he has domestic violence cases where the perpetrator the defendant, post-conviction, can actually live with the victim as long as the stay-away order isn't there. And I said, how do you do that? It's a protective order, and yet the people can live together. And he said, no, we just removed the stay-away, and mom could reunify. So I said, well, I don't think our judges will do that. Will your judge actually, can we get some kind of document or minute order that says, you know, for peaceful visitation, and that this criminal restraining order will not affect the dependency's reunification so that the children can go home? And he said, yeah, I'll try to get the judge to do that. I'm waiting to see right now what the hell got created, because if you have a restraining order, how do you get people to live together again? And especially if our client is charged with child abuse and there's been a conviction in the criminal court, or at least a no contest plea in the criminal court for child abuse, how do you get the parent back with the child with a criminal restraining order?
So protective orders and restraining orders are kind of tricky because there's so many different boxes that really do change the nature of it tremendously. And the two, I guess, boxes at issue in this particular scenario is there's a no contact and there's a no negative contact. So the no contact is there's no way that he can be at the house, there's no way that he can see the wife to exchange the kids. Oftentimes the clients do, and they just don't report it to the police and it isn't a problem, but a lot of times they get in trouble for another reason and suddenly they realize that they were seeing each other and then the person gets violated. But if it's a no negative contact order, no negative contact has been interpreted by the criminal courts at least to mean you can live together, you can share a room, share a bed, you know, live your life the way you have been living before, minus the fact that, you know, if you have negative contact, she can pick up the phone or he can pick up the phone and have you arrested. And negative contact could be anything from he started yelling at me because I, you know, burned the toast, or, you know, he was, you know, threatening me or doing something more serious. So negative contact has a very broad connotation. So those orders exist, but I always tell my clients who are the restrained party that this no negative contact order is really problematic because your partner now has you by the throat, because if you screw up anything, and even if you don't screw up, even if you're living at the house and you know you piss him or her off, and they say, hey, I want him out of here, we've had negative contact, and this is a no negative contact order, then the police will come and violate the person for violating the negative contact. So,
and the interpretation of what's negative or not negative is in the box that has to do with the stay away?
No, it just says no negative contact, have no negative contact with the person. So it's more the interpretation of the police officer who shows up to enforce the order once the party calls. He gets to decide what is or isn't negative. He'll possibly forward a report to the city attorney or the district attorney, and ultimately it's their decision. If they say, this is a waste of my time, this is not what the negative contact order is for, I'm not going to file this, get out of my face. Or they're going to say, we really hate this guy's guts and he got off easy the first time and he hasn't complied sufficiently to our standards, and we are going to, you know, get him and we're going to try to lock him up for a while because now he's got a new case, which is a violation of a restraining order, in addition to the probation violation. And the other tricky thing is the probation violation has a much lower standard than a new case does. It's basically a preponderance of evidence and the judge decides, not a jury. So it's real easy to get a probation violation on something like this. So even if the DA decides, I'm not going to file a new case for a violation of the no negative contact order, I will violate your old probation because it's more likely that I can get something on that because the judge will agree with me that this is more likely than not a violation, and you can end up in jail up to the maximum of the initial charge based on the violation of probation. But very good question. Thanks.
Well, the problem is that none of our, not too many, tell me if I'm wrong, but most of the dependency judges, once they see that criminal restraining order, they interpret it as a no contact order, except for monitored visits. That's it. So in my discussion with the PD, I was like, oh my God, I don't know how we educate our judges, because I have a feeling the criminal court judges that create the restraining order and the dependency judge who thinks that they are following the criminal court judge's orders, it's not correct.
Right.
And it really, for the parents who have the child abuse criminal convictions, county council is interpreting that as if the child can, other than visitation, could never, it precludes reunification completely. So I don't know how we fix that other than maybe going to our presiding judge and asking from the criminal court judges to come educate our judges. But there's a real problem there that I think we need to be aware of, and we need to begin educating our judges based on what you just said.
Well, and if the client has a copy of the protective order,
Always have it.
Oh, they always have it. Okay, because I mean, it seems like if you're going off of the letter of the law, and you can show the judge, look, there's 2 boxes. This one is checked. That one is not checked.
They just see restraining order.
Right.
Done.
And do you know if there's any case law that articulates what negative contact means? Is there anything that, or is that something we can search for? That you think
I haven't litigated that, so I'm not familiar off the top of my head, but I could look into that and see.
we had some authority that.
Right. Absolutely.
Part of the question I think that Marlene was asking is, in our courts, we can commonly ask the bench officers to put in the minute order some clarification of what is being ordered. Would public defender or criminal defense attorney be able to do the same if they know that there's a dependency matter and they're concerned of that affecting the family in the future? The attorney knows the parents are going to get back together, then in the minute order it specifically says the parents may live together so that they can show that to the dependency court?
Yes. So a lot of clerks who have practiced in DV court for a while, they will automatically put in the minute order for clarification, knowing that someone's going to look at this later. Either judge issues this kind of order, which is no negative contact or no contact order, or a stay away order. They'll put, because really there's only like 4 or 5 relevant details that need to be in there. If there's a stay away, how many yards, who the named people are, if it's no negative or no contact. And they don't, I guess like every court clerk, they don't actually type out all the minutes, they just hit F1, 3, F4, whatever. So they could easily put that in there. If it's not in there, which also happens sometimes, you can go back and ask the clerk to non-pro-tongue modify the minute order, give you one that does list those details. But I've always had good luck, at least in criminal court, with just showing up with the physical order and explaining to the judge, because in criminal court they're more familiar with them, and say, look, this is not a no contact order, and the judge says that's fine, we're going to let that go.
You've used the phrase no negative contact order. I've never heard that before. Our clients oftentimes will say level 1 restraining order or peaceful contact. Is that all the same thing?
So level 1 peaceful contact are the same thing as no negative. No negative is basically just the language next to the box. Have no negative contact with the protected person or parties. But yeah, they're the same thing. Thanks for clarifying that. Other questions? Yes.
Level 2.
Level 2?
Yeah.
So that's going to be the no contact. Yeah. And I haven't heard of a level 3. That's it. So I'm going to just go over the first 4 because these are the most common that I see and that probably you will deal with. And the other ones are the civil harassment, protective order, which is not in the family context, elder independent adult, which you guys aren't going to deal with. Workplace violence or college campus protective orders. But we'll start with the emergency protective order. This is the one that they get on the spot when they call the police to come over, whether it's domestic violence or otherwise, and they can demonstrate to the police officer that there's an immediate and present danger to the partner of the child. The police officer will give it to them on the spot, serve the restrained party on the spot, and basically tell him you gotta move out, you gotta find someone else to spend the night tonight. He's not entitled to a hearing right then and there. They will have a hearing later on for it to be adjudicated if he's gonna contest it. But essentially, all they have to do is articulate a reasonable threat, and a lot of times it's a mark, a bruise, a broken vase, you know, a broken window, something like that. And that's enough to get an emergency protective order. And they can get it 24/7. If you can get a police officer at your house, then you can get an emergency protective order at any time of the day or the night. And it is valid until a maximum of 7 days. So if the person wants to contest it, there's a hearing that's set within 7 days so that the parties can appear before the judge. And then the judge can decide if that emergency protective order turns into a temporary restraining order. Yes?
So first of all, for the emergency protective order, can the police do it without the consent of both parties?
You know, usually someone's requesting it. It's not something that they just do on their own. I've seen victims strongly encouraged to sign an emergency protective order, and usually their kids are used as the strong encouragement, which is, hey, if you don't get this protective order and he doesn't get kicked out of the house, then we're going to have to call CPS because we don't think that the kids are safe here. So I've seen that more times than I can count, where the wife's like, I didn't want the order, but they said they were going to take my kids, so I told the officer I needed the order just so that he wouldn't take my kids or have them taken away by CPS. That's always been mind-numbing to me, but obviously I understand the concern. If the guy's, you know, pissed drunk and violent and aggressive and it's not a safe place for the kids, they got to do what they got to do. But at the same time, it's strange to have a spouse say, I had no intention of asking for a protective order, and they basically used my kids as a way to keep me from saying no.
And what happens in 7 days if no one appears for the judge? Is it gone, or does it automatically turn into something else?
That's a good question, because usually the person who requested it is going to be there, and if the other person doesn't, then it turns into a temporary. But if nobody shows up, you know, because I don't actually go to those hearings as a defense attorney, I haven't seen if that gets dismissed or thrown out, so I will look into that because I don't know.
So that might be a way that some people might not know there's a protective order if they're not showing up to these hearings.
Right.
I believe that it lapses, so that comes up. Some of our clients saying that they didn't show up to the hearing,
so it just goes away. Yeah, because it does say on the order that it's only good for this amount of time. So if nobody shows up and the judge doesn't convert it or change it, then I assume that it's done.
But if one of the victim wants to continue it or wants to file it, they could proceed at that
yeah,
hearing.
So the next, right. And so also the officer will serve the restrained party on the spot, so there's no service issue, and that's part of their child responsibilities. And that could include a stay away, a no contact, child custody order, and it also includes a firearm prohibition. Do not own or possess a firearm, ammunition. Do not have in the house, if it's not yours and you live in a house where your brother owns guns, either your brother gets rid of the guns or you can't live in that house. I've seen a lot of people get busted for that, where someone's dad or uncle or someone had like a shotgun in the garage and a safe or bullets somewhere, and they didn't even realize it, but they got violated because they were in a house that had firearms. So it's constructive possession. You're living in the house that has firearms. And okay, let me go to the next slide. So you guys could look at this. This is basically a chart of what we had already said in terms of when you can get the order: child abuse, spousal abuse, abduction threats, elder abuse, stalking. Reasonableness is the proof, burden of proof. The orders can be everything from stay away to child custody to firearm prohibitions. And again, it's usually 5 to 7 days max, and those are the relevant code sections. Now, if the parties do show up to court, and the person who asked for the order is there, it becomes a temporary restraining order. Temporary restraining order is granted upon showing of recent abuse, threats of abuse, stalking, threat of stalking, sexual assault, or any behavior that can be enjoined under Family Code Section 6320. And again, this has to be done obviously during court hours in front of the judge. And it can also be done without the emergency protective order. I have people who will walk into court and say, I need a temporary restraining order against my spouse for this reason. They will set it on the same day. They have to set it on the same day unless you walk in at 4:45. They'll say, come back in the morning and we'll take care of it tomorrow. This can be granted with or without notice to the protected person. If it's not an emergency protective order and it's a TRO initially, the judge grants it the same day and then gives you another date for a contested hearing where you have to serve the other party. And if the other party doesn't show up, then you get it automatically. If they do show up, then the judge listens to all the evidence and decides whether or not it's going to stick. And basically, the order is the same thing. It will prohibit striking, attacking, stalking, threatening, everything that's listed in the order. The court can also make custody and visitation orders based on that, firearm orders. And this one is valid for up to 25 days. That basically gives the protected party enough time to serve the person who's probably going to avoid service if they know it's coming. You can ask the sheriff to do it, but you have to serve the person within 25 days. If you don't, you go back to the judge, explain to them that the person's avoiding service, and they'll give you a brief continuance in order to try to have them served or call the sheriff's department and get them served. And that hearing is set 20-25 days out. And that's the chart. It's in your material. And a criminal protective order is the one that happens after a criminal conviction. It's issued upon showing of harm, intimidation, dissuasion of the victim or witness, or that that's reasonably likely to occur based on what the judge knows. Anytime during a criminal case, so this is when a case is filed or adjudicated, the judge has the authority in criminal court to do this based on whatever is presented to the judge at that time. Knowingly and it also addresses knowingly and maliciously preventing or dissuading a witness from attending or giving testimony. So even if it's not the spouse was abused, it's this person is trying to prevent a minor or adult child from coming to court and testifying, or a neighbor or another witness. So I've seen CPOs served on unrelated parties. Like the guy down the street who doesn't like me is coming to court to testify against me. So I'm going to go over to his house and tell him, you better not come to court. There's a CPO issued for that too. And let's see.
Question really quickly?
Yes.
So what if neither parties show at the criminal hearing and it's sustained and a criminal protective order is issued? Is that one way the parties might not know the criminal protective order is there? Or will it not be issued if none of the parties are there?
It'll be issued whether or not any of the parties are there. And if the defendant is, the defendant will be there. I mean, they can't convict or sentence anybody in criminal court unless the defendant's there. Otherwise, they issue a warrant, bring him in on the warrant, and it's a due process issue. You have to be present for any kind of sentencing or conviction or anything like that. But certainly the protected person may have no idea. The protected people, oftentimes for good reason, don't show up to criminal proceedings because it's not their proceedings and they have lives and other things to do. So it's very common that they won't know that there's an order in place at all. And they may not find out until their spouse tells them or somebody else tells them. All right, we're coming up on 1 o'clock. I want to make sure I get to questions instead of the rest of the slides. Yes, hand in the back. No? Yes.
If the defendant is acquitted or the charges are dismissed, then the restraining order would just end, right? Because that's the termination of jurisdiction. But does anyone file any paperwork to say that the restraining order ends, or do we just have to know that the case is over?
So the criminal protective order, if it was issued, good question. If the criminal protective order was issued before the client was convicted and either pled out or sentenced, then the judge will, on his own motion, supposed to, because he loses jurisdiction, and if there's no conviction, then the criminal protective order will go away at that point.
But does someone file the paperwork, or like would the PD file the paperwork to do that, or would the DA have to file to remove the restraining order?
That's usually something that the clerk does on the judge's own request. So the judge says, okay, case is closed, case is dismissed, and then the criminal protective order is no longer valid because the case got dismissed, if it gets dismissed. If the protected person still wants something, they can apply for a non-criminal protective order, which is just a temporary restraining order, and have it continue. But the CPO should die once the case dies without a conviction. Does that make sense?
Yeah.
Okay. Other questions? Yes?
So for the criminal protective order, it says that it may be modified by stipulation or at a court hearing at the request of the protected parties.
Yes.
So if the protected party is a child, does the parent or does the defendant have any ability to come to court, say, a year after the criminal protective order was issued and say, hey, I did, comply with juvenile court, family reunification services, I did counseling, I did parenting classes, may I have the CPO lifted?
I've never seen a court do anything or touch a protective order without addressing the victim first.
But how about if the victim's like 3 years old or something?
Oh, that's a good point. So it would be a victim or a guardian, or they'd need some additional evidence that they're satisfied that this guy's not just trying to, get out of the order so that he can do more harm or just see the kid because he wants to.
Okay.
Yeah, so I've never seen it where the protected party alone is enough to have a modified order. I've always seen the judge ask, you need to come back with somebody or additional evidence or additional parties that can testify as to why the order should go away. It just seems too self-serving, yes.
Well, isn't that why we have this unpublished opinion? So that we understand what we need to do, because under the rules of court, what we should be doing, just as long as I was explaining before, where we're in contact with the PD to try to make sure when the first CPO is ordered by the court that there's no preclusion to reunification, that we have this, it's very clear that this is a, what do you call it now? When the first, there's no stay away.
Oh, the no negative contact.
Yeah, the level, stage 1, level 1.
Right.
Make sure that that gets inputted into the CPO. In addition, the court rules mandate that our judges absolutely can call the criminal court judge. If we find out and we figure out who it is, they can talk to each other. And our judge can explain to the criminal court judge why there needs to be an amendment to the CPO for let's say it's time the kid should go home. And we want to make it very clear, the CPO won't go away, but there will be an agreement between the judges or some discussion between the judges to allow for full reunification so that the child could go home. So you don't need the victim child, you have the dependency judge. They must talk to the criminal court judge, and maybe you can have a remedy that way.
Yeah, and I highly recommend that because all of the criminal judges that I've talked to are always very partial to whatever's going on in dependency court.
Absolutely.
So if they get a call from the clerk here saying we want to do this,
Right.
it's a no-brainer for them. They're not trying to be a wrench.
Right. This is an unpublished opinion, but it's your guide to what we can do.
A couple of just practice questions for us. A few different scenarios that come up with some regularity. We might have a criminal case for a client, but it's like a low-level misdemeanor drugs or DV. In my experience and from what people have told me, the information of what's going on in dependency doesn't usually get to the DA or the criminal court on those really low-level offenses. So if we plead somebody out here, it's not necessarily likely to impact the criminal case. If that's not true, let me know.
Yeah, that is true.
Okay.
And I've before talking to you, because I didn't know myself how often the DAs get involved with dependency stuff. All the DAs I've spoken to say that they don't really show up or communicate or call.
So if it's not like a child endangerment or a big ticket case, if it's just like a low-level misdemeanor type case, we
They're
probably
not
don't
interested.
Second of all, on the big ticket cases,
Right.
D cases, where they're in our court alleging child sex abuse, we often have cases where the investigators, the detectives are still sniffing around the case. They might have interviewed a client. They might talk to the kids. They haven't filed anything, right? And now we have our case. And it's always like a conundrum, right? Because it's a case that might be settlable or resolvable. But then we have a plea on the dependency case. They haven't yet filed in criminal court. Is that something that can be used against them later, even if there's not a current filing?
So my understanding is no, and investigators obviously don't come into court and hear what's going on.
Well, but sometimes county council will call them.
Sometimes county council will.
We do have some very overactive, zealous county councils that might reach out.
I mean, that ideally would be a policy issue where maybe some of the higher-ups at LADL can talk to some of the higher-ups at county council, because, I mean, that shouldn't be happening because it throws a wrench in your job to be able to effectively, do what's best for the kids and the families if they're worried about what county council is going to do. I hadn't seen it. I hadn't seen that happening, but if it is, off the top of my head, I can't think of a way around that. I don't really know what to tell you.
And the other question I have that's similar is, if a child testifies in the dependency court, and then for whatever reason is deemed unavailable in criminal court, can they use that testimony out of dependency?
It depends on the reason why they're unavailable. So in the evidence code, there's an unavailability of a witness exception. And if the unavailability was a result of something that the defendant did, then absolutely they'll bring it in. But if it's just that the witness moved out of state or left town with mom or was deported or something like that, that can't be the fault of the defendant, and that would not make it otherwise admissible.
So like not forfeiture by wrongdoing, right?
Exactly.
And should we be concerned with other testimony if we have a client testify? Should we be worried about what might be used against them in the criminal case?
I mean, I always get nervous anytime I hear anybody admitting anything as a defendant, just because there's a record, there's a court reporter writing it down, and there's always so many zealous prosecutors looking for any which way they could possibly get into a record that they shouldn't otherwise get into. So whether or not the law is on our side or their side, I think it's just good practice to try to keep incriminating evidence off of any record that you can all the time. Because if there's not an exception now, there may be 2 or 3 weeks from now if legislation changes or something happens, and suddenly that becomes something that's admissible in criminal court. So I always say if there's any way to keep something like that off the record, we do, yes.
One, remember under 827, the DA has access to all of full court's files. So it's not just for testimony. That's why you have to be very careful to make sure your client probably shouldn't be interviewed by the social worker because the DA has access to all of that. I've been in cases where the court has allowed the DA to sit in on our trials. And 3, the only time that testimony can be used against a client in the criminal proceeding is if our client chooses to testify in the criminal proceeding, and our testimony can be used to impeach him or her. So for all of those reasons, it is in the client's best interest, if it's a serious criminal case and you know, or not a serious, if you know there's really an investigation and there's a criminal case, be wary of clients' interviews in social workers' reports, and certainly you need to assert Fifth Amendment privileges at that point for privacy purposes.
I only got a couple more slides. Are there any other questions? Yes.
Do you know whether public defenders are trained to not plead down their vicious felonies to child endangerment felonies? Do they know that's a basis for bypassing reunification?
No, usually no. And
perhaps you could spread the word.
I know.
It doesn't really help.
And I think in my 10 years of public defender and private practice, I've always been surprised by how little private attorneys and public defenders know about immigration consequences and dependency consequences of convictions, because in their mind, if you have a heinous felony that you can get the client a misdemeanor with no custody time and summary probation, that's like the goal. And you don't necessarily consider the dependency consequences because you're not educated on it or informed on it. So that's a problem. Similarly with immigration, sometimes somebody pleads to something that they didn't realize is a deportable offense, even if it's a misdemeanor, thinking that this is so much better in terms of the overall consequence in criminal court that they didn't consider the consequence in other courts. So yeah, there needs to be a lot more collaboration between our work for sure. And I would love to hear ideas on how to make that possible, because the defense part needs a little bit of help in that regard. Last thing I was going to mention was the modification that already came up, but criminal defense attorneys are the easiest persons to help with that. If the victim wants to do it, they're not necessarily going to know the process. So a criminal defense attorney will go to court, add it to the calendar, tell the person when to show up, and what they, who they need to talk to, what to say to the judge, and it happens pretty quick. When the person shows up on their own, I've seen the judges browbeat them a little bit more and give them a little bit harder of a time to make sure that the husband didn't put them up to it. But when the attorney gets up there and says, hey, this is the situation, this is why they need a modification, and he'll ask the victim a couple questions like, is this your desire? Are you doing this on your own free will? Is there any kind of coercion? No, okay, we're done. But without an attorney, sometimes they get turned away because the judge might hear something in their testimony that he thinks he heard coercion, or he thinks he heard somebody say something that sounded like, well, my husband, talked to me about this and this, and that was enough for him to say, no, that's coercion, I'm not doing it. So it does help to have a PD or a private attorney get it on the calendar and speak when necessary. And then, as noted, the local rule about contacting the other courtrooms in the other place. Other questions? I got a few more minutes.
Do you have any suggestions for how to find out who our client's criminal attorney is when they don't know?
So the question is, how do you find your client's attorney when they don't know? Sometimes if you go on the county website and you pull up the case information, if it's post-arraignment, because at arraignment, sometimes it'll list the name of the public defender who arraigned them, which is usually not the public defender who's assigned the case. There's usually an arraignment attorney who does all the arraignments, so that's not going to help you. But if you know which courtroom or which courthouse it is, it's easy to call the main public defender number at the courthouse and say, I got this client, I need to talk to his attorney, who's their attorney, and the receptionist can just type in the information, tell you who the attorney is, and patch you through to their extension. So if you know, I would say get the case number if you have it, name and date of birth is really all you need, and then the courthouse that he's in, and the PD's office will have that readily available, and they don't keep that information private, and especially if they know that you're an attorney, they should try to make that easy for you. But good question. Yes?
I just want to clarify, what, if any, effect do you think that a no contest plea in our court would have on a criminal case? Like specifically with DV, because in our court, the county council will allege this long thing, like the father punched and slapped and like held a knife, and then we might think, oh, well, we want to settle that with just like father pushed the mother. But in criminal court, that could still be a misdemeanor, right? So do you think that it would have an effect on the criminal case if there's a DV charge if he pleads to something without language?
So I did 2 rotations in DV court as a PD, and I've never seen a prosecutor have that information. I've never seen a prosecutor present, hey, this guy's got a plea out of dependency court where he admitted to this by pleading no contest. So I don't want to give you a false sense of security and say it shouldn't have an effect, but I haven't seen it. In 10 years I haven't seen it. Not to say that they're not going to be able to pull it and find it. If they do pull it and find it, and they find out, I mean, technically, the benefit of no contest is that you're not admitting guilt. You're basically saying, I'm not contesting it, and that says that this cannot be. The judge will read after the conviction, they'll say, do you understand that a no contest plea has the same effect as a guilty plea, except that it cannot be used against you in future proceedings. So technically, they can't say that it's an admission of guilt because it's not. It's basically saying, I'm just not contesting the charge because I want to resolve this for the benefit of, seeing my kids and getting my life back in order.
You can't do it because of the burden of proof. The reverse can happen. A no contest plea in the criminal court, all county council needs is a certified copy of that conviction because of the burden of proof. The reverse for us. They can't use a civil, our plea is at the same level as if someone is found during a lawsuit to have done something. We are civil. They can't piggyback, they can't use the civil, they've got the higher burden. So the DA has to prove their case beyond a reasonable doubt. They can't use us or any of our information but for impeachment purposes. So don't worry about that when if you're resolving the case. The reverse we have to be very careful of, because when our clients enter the plea in the criminal court, if you have a smart county counsel who's not lazy, they will have gotten the certified conviction. As far as I'm concerned, all they got to do is give the judge the certified conviction and say, hey, by beyond a reasonable doubt, this person entered the no contest plea. That's it for us.
Thanks. All right, last question? I'll also leave some cards up here if anybody has any other questions or wants to email me, feel free.
Let me know your time. She's already.